Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic is, what's the deal with data portability? Understanding the competition and privacy aspects surrounding the movement of data. Our Curious Amalgam is going to be taking a deep dive into the topic of data portability. Right now, policymakers, companies, and others interested in the field of competition, privacy, and cybersecurity are considering the implications regarding what has been termed data portability. Today, we're going to spend some time getting familiar with the concept of data portability, the ability to transfer or move a person's data. Next week, join us for a second installment when we'll be examining a proposed framework for assessing initiatives related to data portability and other required data transfers. Joining me today is my co-host, Kayla Odom. Hi, Kayla.
Hi, Christina.
How are you?
Good. Thank you.
So, Kayla, what are we hoping to get out of today's episode?
Well, with the enactment of stronger privacy laws in Europe and in California, issues of data portability have been brought to the forefront. Given this recent traction in the area, it's important to take time to understand what data portability is and how it affects us. So today, we're looking to get a better understanding of what it means for data to be portable. We'll also consider how greater portability of data may affect competition. And on the other hand, if portability of data is too easy, how will that affect an individual's right to privacy? Today, we're going to have a discussion about these two tensions and learn how data portability is currently being addressed in the law. We'll also consider some of the implications that policymakers and companies are already considering when it comes to data portability, and hopefully get some ideas about where things might be headed.
Great. And who are our guests today?
Our guests today are Brown and Gabe Maldoff. Both of our guests are actually two of the contributing authors of the comments submitted by the ABA Antitrust Law section in connection with the Federal Trade Commission's Data Portability Workshop that took place in September 2020. Brown is a partner at the Atlanta office of Alston & Bird, where his complex commercial litigation practice focuses on high-stakes antitrust, IP, consumer protection, and data privacy matters. Is also a member of the Antitrust Law Section's Privacy Legislation Task Force. Gabe Maldoff is an associate in the Privacy and Cybersecurity Group at Covington & Burling, where he advises global clients on privacy, data protection, and technology law issues. Gabe has also served as a fellow at the International Association of Privacy Professionals, and his research on privacy and national security laws has been featured in journals in the US and in Europe. And Gabe, welcome to the program.
Thank you, Kayla.
So let's get right into it. At a basic level, what is data portability?
Thanks, Kayla. The definitions can vary, depending on the law or the source, but at its core, data portability is simply about an individual's right to get personal data that he or she has provided to someone and to give that data to someone else, presumably for some specified purpose. It does not really include data that's generated or owned by third parties, including companies or like online platforms.
Can you give us some examples of what an everyday person might encounter? What kind of personal data would be likely to be portable?
One example would be if you post a photo on a social media platform. That would be data that you included, or some other data about yourself that you inserted into a social media platform would be an example.
This can go to either Alex or Gabe. Does the portability of data differ based on what kind of data it is? Like, is it easy to move things from one place to another? If it's my personal documents on my Google Drive, it seems like it would be pretty easy for me to switch that over to my iCloud, for example. But is there certain kinds of data that is portable that we don't know about? Do you have any thoughts on that?
I can jump in on this one. I think that you're hitting the crux of the problem that data portability laws are trying to solve. There is this notion that making it easier for consumers to switch their data from one service to another might facilitate competition or improve privacy and control over data. But what exactly that should look like in practice, which data types that should apply to, and how exactly that right should be exercised is really up for debate right now. And we're seeing different jurisdictions approach it differently.
So let's talk about the competition issues that come with data portability. Alex, why is the ability to move or transfer data an antitrust or competition issue?
Well, that's a good question. A substantial number of growing technology companies have spent years collecting data about their customers. Users, typically consent to the use of this data, at least by that company, and then the data is in turn used to determine what products or content to market to a user, how to market to them, and potentially keep them using the platform. The more data you have, potentially the greater ability you have to drive forward and grow your platform and arguably lock in the user to some extent. If the data is not shared or available to be shared with potential competitors, then the incumbent company potentially has an economic advantage. Giving consumers a right to portability of data arguably allows them to move more freely from one platform to another, increasing competition.
Now, is there any indication that consumers would have to pay to transfer their data, or when they use these services, is it kind of understood that they have that right to do that?
It depends on the terms of service of the individual, but that's kind of one of the issues and one of the reasons why states and countries, including the United States, have been discussing a data portability law, or really a larger data privacy law that would include data portability as a potential right.
Is there discussion as to the right scope of legislation? So, can states actually legislate around data portability? Does it have to be federal? Should there be multinational legislation or guidance on the topic?
It might be worth kind of taking a step back and looking at the way data portability is currently legislated and sort of what's being proposed. And at a high level, there are two kinds of portability laws. The first are a batch of sector-specific portability requirements. So the quintessential example of this is in the US, there's phone number portability. The Telecommunication Act of 1996, perhaps one of the most successful examples of portability, requires telecommunications companies to allow you to switch your number from one service provider to another. Millions have done so quite seamlessly. And there are other sector-specific examples, like in the health sector. Your guest next week will have others. He uncovered some state laws that require portability or that facilitate portability for auto dealers in a few states. And then the other bucket of portability laws fall within the bucket of privacy laws. And we have seen jurisdictions legislate portability under privacy law frameworks. So famously, the European Union's General Data Protection Regulation includes a portability requirement. And California's Consumer Privacy Act also has a portability requirement. And we can talk about exactly what types of portability requirements are out there as well. But just to give a flavor, those are sort of the range of what's out there.
Okay, so you've got privacy laws, if they exist. You mentioned the GDPR has a strong privacy law, and California does. And then you mentioned sector-specific laws. So it sounds like the U.S. doesn't have an overall encompassing law that would address data portability, because they don't have an overall encompassing privacy law. Is that right?
Yeah, it's a good question. So the short answer is no. There is no overarching portability requirement in the US that applies to personal information broadly. However, it's a bit more complicated because portability comes in different flavors. So one way that portability is legislated is by allowing consumers to receive a copy of their data with specific formatting requirements so that it's easy for them to take that data and move it over to another provider. Another portability requirement might be more advanced, and it might require direct transfers from one provider to another. And you could imagine a hypothetical law in the future that might even require more advanced data sharing arrangements where the data is synced between providers, and changes in one would result in changes to the data for the other provider. So those latter two categories don't exist in US law. The sort of right to receive a copy of the data with format requirements exists in California law under the CCPA. And at the federal level, there are privacy laws that require access to data. They just don't necessarily dictate the format in which consumers are required to receive access.
I see. Now, let's look closer at the issues that consumers might face with respect to data portability. So we talked about there could be competition or antitrust concerns like lock-in or potentially lower switching costs for consumers. But Gabe, can you tell us about why data portability is a consumer protection issue?
Yeah, so there are a number of reasons. I think the first is going back a long time, privacy laws have viewed the ability to gain access to your data so you can correct mistakes as being an important consumer right in relation to information. And portability is sort of an extension of that in many cases. But then in addition to that, there's this element of control. So under privacy laws, we often want consumers to have choice over how their data is used. And so portability, being able to take your data from one provider to another, looks like a more advanced version of control. Proponents of portability often, portability from a privacy perspective, will often mix the competition and privacy rationales as well. And what I mean by that is there's this well-known phenomena of the privacy paradox where consumers will express preferences for privacy protective services, but then the way they act doesn't always reflect their preferences. And there are proponents of portability from a privacy perspective that think if you can reduce the switching costs, then consumers might actually take their data to services that have privacy practices that align with their preferences. So for example, European regulators put that out in one of their position papers, in a draft of their position papers, but they later retracted it. So it's not clear whether that's the prime motivator. Alex, you might have some other thoughts on the consumer protection rationales here.
I think that was a great summary of the key issues. I was going to circle back too and kind of tie in a couple of examples of the laws where consumers have an interest in their data, and now as a result of a couple of federal laws have the ability to go access it. The Fair Credit Reporting Act is one, and HIPAA obviously gives people the ability to go and get their medical data, and so having the ability to access that data, having the ability to move from provider to provider in these specific sectors, has proven to be a consumer benefit. And so that's kind of what the larger potential law is looking at and trying to help folks on a broader level.
What I think is interesting about what you guys are saying is also just the intersection of privacy and competition interests. presumably if your focus is on competition, you may regulate data portability differently than if your primary focus is privacy, although there are, intersections. Alex or Gabe, has there been, it sounds like a lot of it's coming out of privacy legislation. Are we seeing antitrust regulators, agencies, either approaching mergers or other conduct differently with data portability in mind? Or is there broader legislation focused on antitrust as the primary rationale to address data portability?
Yeah, from an antitrust perspective, I don't know that the approach has really been that specifically focused on data portability, but that kind of tension between antitrust and privacy rights and the potential impact of data portability is something we can see, for example, in the lawsuit that was filed by the Department of Justice against Google in October. One of the issues from that lawsuit was, the potential, the accusation that Google is a monopolist in the search and advertising market, and that as a result of that, the people that use Google are essentially locked into the privacy policies that Google, has. And so if they were able to use a different company for search, then potentially there would be more competition over privacy. So the federal agencies are obviously looking at this. Several of FTC commissioners have commented on this, but it hasn't kind of got specifically to the legislation.
And I would say that also, while portability can support consumer protection and privacy interests through empowering consumers in the way we discussed, it can also be in tension with privacy for a few reasons. First, just the technical challenge of making data available so that it can be transferred to another entity can result in security risks, including risks that a company receives fraudulent requests for data and then discloses it. So that's a major privacy and security risk. And then more thorny questions are raised where data implicates more than one individual. So to take Alex's example at the beginning, if I want to move my photos from one service provider to another, that seems like the example, a quintessential example where we would want portability to be able to switch services. But that's also the type of information that might implicate lots of people. And so what are your responsibilities in relation to those other consumers whose information is wrapped up in those photos? What happens if the recipient service doesn't have the same level of privacy protections as the initial service? And how do we resolve these kind of social data issues?
Devil is in the details.
I wanted to ask a little bit about how this works in practice. So if I'm a consumer in California and I supposedly have the right for my data to be portable between formats, I guess it would depend on the specific portability requirements in California. But how would if there's a challenge, if my provider doesn't allow me to move my data where I want to, what do I do? How is this getting enforced? Are we seeing anything yet on this front?
It's a great question. So I think to go back to a framework I hadn't really articulated very well, but I think there are kind of different levels of portability requirements, even within these privacy laws. And so the first level is this, you get access to your data, you get a copy in a format that you could be able to transmit. So it's portable, it's machine readable, it's electronic. And that's effectively what California law requires. So it isn't a requirement for direct switching. The consumer can get a copy of their data. What they're able to do with it afterwards isn't necessarily legislated. There are kind of more advanced portability requirements. The GDPR, for example, says that where technically feasible, a provider should facilitate direct transfers to another provider. But that where technically feasible language is doing a lot of the work. If it's not technically feasible, then you fall back on not having a clear requirement. So where we're at now is that organizations are very effectively making available tools to consumers to be able to access their data in structured and electronic formats. That avoids, problems we used to see around, getting a copy of your data in the mail, which isn't very convenient for anybody. But in terms of true portability, we're seeing a lot of challenge in making that operational. And likely more of the success is coming in those sector-specific areas where there are clear standards emerging, either because of legislation or regulators issuing rules on exactly what the standards are to permit and facilitate sharing across ecosystems.
I see. I wanted to go back to something I mentioned earlier. I mentioned that both of you worked on comments that the ABA antitrust law section submitted in connection with the FTC's data portability workshop. So I was hoping each of you could kind of tell me what are you hoping that people will be able to take away from the comments and the ABA's position on data portability, and maybe some of the takeaways from the FTC's workshop that are memorable.
Sure, I'll start and just kind of say thank you to Henry Sue and the other 12 or so folks that spent a considerable amount of time working on these comments and putting them together for the section. It was quite a project, and I learned a ton getting to work with all of these privacy experts. And I think for me the big takeaway from it was that we're kind of early on in this process, and a lot of smart people are looking at this in a lot of different ways, but people are going to need to continue to do that, and maybe not rush to legislation before we really thought through all of this. Gabe, anything to add?
I agree with that. I think what we concluded was that there really hasn't been a lot of empirical study, and the kinks are still being worked out in how portability is being operationalized in practice. And so I think we didn't come out with a definitive conclusion other than that we should exercise caution before regulating in ways where we don't have perhaps enough information to know the impact.
Great.
So I think that segues kind of well into sort of more personal questions. We like to ask both our guests, or all of our guests, but both of you, for those of you who, what advice, I guess, would you give to younger attorneys, law school students who are looking to do what you do, to be involved in the ABA as you are, to get even involved in the comments as you guys did?
I just reach out, reach out to the people that you think that you're interested in their work. 9 times out of 10 people will respond. Just send them an email and get connected. Once we love to see interested young lawyers and law students get involved.
I would say from my perspective, and this is highly biased because it's based on my own experience, but I would say it's don't be afraid to specialize. The law can seem like this sort of big, overwhelming profession, but actually you learn as you get into it that it's a number of smaller, more cohesive communities. And if you're willing to kind of follow an interest down a rabbit hole, you can find your community, which I find to be really helpful and makes working more fun too.
And for both Alex and Gabe, can you tell us something about yourself that we wouldn't know about you if we only knew you professionally?
Sure. My family and I recently adopted a puppy. He's a black lab coon hound mix named Walter, and he is currently terrorizing our house. We love him dearly.
How old is he?
He is 10 weeks old, so we just got him a week and a half ago.
Adorable. Enjoy that. And Gabe?
I guess if I hadn't ended up becoming a lawyer, I hoped that I would have become a ski racer, but that was not a very promising career choice, mainly because of my lack of ability in it. But anyway, I do still sometimes wish I was out there on the slopes.
Great. We all have things that we wish we were. I don't know how many of us, at the age of 5 said we really want to be a privacy lawyer or an antitrust lawyer. Great. And now for our final segment, what we like to call the Curious Hat.
And now it's time for the Curious Hat.
So in normal circumstances, we would have a physical hat that we would hand you. Obviously, we're doing this all virtually. So I don't know who I'm going to choose. Alex, why don't you pick a number 1 through 25?
Go with 17.
17. Okay. So Alex, what was your favorite course in college and or law school, and why?
My favorite course was, I would say, sports in law school. I'm a big sports fan, as well as obviously a lawyer, and I had a great professor. And it was actually really my first introduction into antitrust law, because a lot of the big antitrust decisions had to do with the professional sports leagues.
That's right.
So it got me interested in that as well.
Mm-hmm. And Gabe, if there was one course you could have taken but you didn't take in undergrad or law school, what was it?
Oh, good question.
Skiing? No.
I always wanted to take an art history course in undergrad, but they filled up so quickly. I don't really know why I wanted to take it. I just don't know much about art and thought it would be interesting. In law school, I probably should have taken something like contract drafting or more practical than like conflict of laws, but it was interesting.
Great. And these are all, of course, facts that are probably not out in the ether, but now everything is known as all of our data becomes known to someone or somewhere on Facebook or elsewhere. Anyways, Alex and Gabe, this was wonderful and incredibly informative. Thank you for your time today. And thanks to our listenership for tuning in. And we hope to see you next time and next week for a second installment on data portability.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.